Hello, I'm Philip Sales. In this video I'll be interviewing Stephen Laws, first Parliamentary Counsel, about how Parliamentary Counsel sets about drafting an Act of Parliament. Stephen, what happens when a set of instructions arrives in the Office of Parliamentary Counsel?
The practice is the government department will send a set of instructions to me, the first Parliamentary Counsel, and ask for a drafter to be allocated to the bill. That's the theory. In practice, quite often we know the instructions are coming and there's been some preliminary work and I will have chosen someone. But essentially, as soon as I know that a bill is needed, I will try to put together a team of drafters from the office who will work on the bill. Traditionally, we divided ourselves into a number of teams of two and operated more or less a cab rank system for allocating bills. But what tends to happen now, in larger numbers, is that I put together a team. I decide how many drafters it would be appropriate to work on a bill. We sometimes have as many as 5 or 6 working on the annual finance bill. On the other hand, a short bill will only have 2. We try not to have individual drafters working together because we operate what we call the 4 eyes principle, that everything that leaves the office should be read by the person who drafted it, of course, and another drafter for checking purposes. So I put together a team and I send them the instructions, and then they get in touch with the department about how they will proceed with the drafting.
How does a drafting team set about the task of drafting a bill?
The first task, of course, is to read the instructions and to decide what's wanted. Very often the team will want to meet. Indeed, I think it's best practice for the team to meet with the departmental team in order to talk round the issues that arise out of the instructions, and also generally to get a picture of what the political purpose is behind the legislation and what the various constraints are on the department. They will read the instructions, and then normally there are questions of various sorts. Different drafters work in different ways. Some drafters will start the thinking process by roughing out a draft and using that as the basis for discussion. Others will go through a long list of question and answers with the department on the instructions.
What are the factors the drafter has to take into account when analysing the instructions?
There are a number of factors. There are questions of consistency with the existing law, consistency between propositions within the instructions. The process of analysis operates at various levels. There is the level of sort of logical consistency, but one of the main factors I think that affects drafting is the need to take account of the fact that people's behaviour will change. If you operate on one particular aspect of their behaviour, they may change other behaviours. Everybody knows that you can't rely on everybody buying the same amount of cigarettes. If you put up the tax on cigarettes, the profit from putting the tax up is affected by the fact that some people will stop buying them. And that affects all sorts of other things as well. If you change behaviour in one area to stop something that people are doing, there may be something else they're not doing at the moment that you wouldn't want them to do, but they might start doing it if you've prohibited the thing they are doing, and that's an aspect of it too.
Is there much of an exchange of views between the drafting team and the department once you've received a set of instructions?
Yes, there's certainly an iterative process. Most bills go through at least 3 or 4 drafts. With there's the initial questioning process before the first draft is produced, and then the first draft will go out and the department will read it and consult people and will decide that there are aspects of it that don't do exactly what they want, or they will decide that in the light of the draft that perhaps they would like to change the policy, and there's an exchange between the drafter and the departmental team.
Do you ever have to say that you're not able to draft something?
Well, there are very few laws that limit what can be said in legislation. The doctrine of parliamentary sovereignty means that Parliament can do what it likes. So we don't tend to say this is something you cannot do for legal reasons. There's the Human Rights Act, there's European law, but that apart, we don't say that the law prevents you from doing this, because it doesn't. But what we often do need to say is that there are risks involved in approaching a problem in a particular way that might impact on the effectiveness of what we draft, and that there are maybe the department should think about other ways of doing something.
How long does the drafting process take?
Well, I think the smart answer is always longer than you think it's going to take, because the process is quite slow. A long 100-page bill, say, might take as long as 10 weeks just to produce the first draft, because the process, first of all, of doing the analysis, the thinking, and then producing it in words that are unequivocal is a long process. And then there is the exchange of drafts that follows on that, and that sometimes is shorter, but it's still quite a lengthy period to produce a bill.
What factors do you consider when deciding how to structure a bill?
Well, there are a number of factors. I mean, one of the first, of course, is to try and put the legislation in a comprehensible form for the reader and the courts. But there are also parliamentary considerations in that the bill will need to pass through Parliament and will need to be debated. So, for example, it would be inappropriate to have the same issue dealt with in a number of different clauses, so that each clause gave rise to the same sort of debate. So you take that into account as well.
Do you have a set of precedents or other guidance that determines how you draft?
We don't have a set of precedents except the statute book itself, which is a large book of precedents. But we tend to find that everything we do is by definition new, and that needs to be thought through from the beginning again. Since we've grown in size, we have got some drafting guidance on various techniques, and they can be found on our website. And we give guidance on questions of plainness and simplicity. We have adopted a practice of gender-neutral drafting, and we've given some guidance on that, and as I say, can be found on our website. What
is your approach to the language of the statute book? Do you try to use plain language drafting?
Yes, we do. I think statutes are often thought to be written in sort of legalese, but in fact the pressure on us is to produce legislation that is comprehensible, because it is discussed by politicians who are not all even most of them lawyers, and that they need to be able to understand it. So it's very important that we should try and make the language as plain as possible. Again, with a lot of things, there is a balance that needs to be struck between consistency with the past, because lawyers rely on the fact that the language is consistent with the past and when it's intended to mean the same thing, and moving on with the language as the language develops and as new techniques are devised in order to produce what is as clear as possible to the reader.
What traps is it important to avoid when drafting?
Well, there are a number of traps that you learn early on. There's the one where you should be careful not to provide for something that happens before a date and after a date, and then forget to have provided for the date itself. And there are difficulties with plurals and singulars, and there are words like any that are ambiguous when you get close into drafting, because it can mean all or it can mean a single one. And these are techniques that drafters pick up quite quickly. And then there are the bigger traps you fall into later of assuming. I think the biggest trap you can fall into is the trap of assuming that whoever is reading your statute will read it benevolently, because that is certainly not what happens in practice.
What tips would you give to someone trying to draft a bill?
I think to recognise that, I think the main tip, the tip I give to most people is to recognise that they have a plain sheet of paper. And we spoke about precedents earlier. And it is a great mistake to think that you have to draw in bits of the existing law, that you have to rely on the fact that the law is where it is. The difference for us is most lawyers are involved in finding a line that has been drawn, perhaps by us. We are involved in drawing the line itself, and we don't have to be constrained by existing structures. We can say exactly what we mean in a straightforward way.
What is the audience for your work?
Well, ultimately, I suppose it's the Supreme Court, because if our statute doesn't mean what we intend it to mean when it reaches the Supreme Court, that is certainly a failure. But on the other hand, it's not enough to write a statute that is comprehensible to the Supreme Court, but not comprehensible to any of the other people that have to operate it in the meantime. So there are lots of audiences that within those who are looking at the Act. And again, there is the parliamentary audience for the bill. So we have to try and look at all these audiences, remembering that it must still work when it reaches the Supreme Court.
Drafting is sometimes criticised as too referential. How do you respond to that criticism?
Well, as drafters will, I will respond by saying I'm not quite sure that I know what that means. I think sometimes it means operating by taking something, an act from the past, and saying it applies as if X with the following modifications. And I don't think that is regarded, except when it's the only possible way to do something, as best practice. Sometimes, though, the expression is used in a wider sense to refer to the practice of textual amendment, so that an act will only operate by taking an existing statute, leaving out some words and putting in another, so that the reader has to have the original act there and to do the cutting and pasting. And I think that textual amendment is the way that we tend to operate now and have done for the last 30 years or so, and is, I think, defensible these days with so much electronic work done on reprinting statutes, so that you can see the effect on it. Although for the parliamentarian it's sometimes difficult, and I know that the National Archives are working at techniques for making it easier for people to see how the bill will operate on the law as it stands.
Drafting is also often criticised for excessive complexity or for being too detailed. Do you think that's fair?
Well, sometimes I think it is, and I think sometimes when legislation is passed in a hurry, it is difficult to spend the extra time that's needed in order to clarify it. And somebody, I forget who it was, who said
Duke of Wellington.
Sorry, his letter was so long, but he didn't have time to write a short one.
Yes.
And that's true of legislation, but there are other factors that contribute to complexity. One of them is a desire for fairness. Very often complexity results from a desire to make sure that everybody's case is taken into consideration, and sometimes that's justifiable and sometimes it isn't. The sort of complexity that should be avoided is the complexity that makes the statute so complex that in fact people operate as a different rule in practice because that's the only simple one that will work in practice. That definitely needs to be avoided. And sometimes the subject matter is extremely complex. I remember drafting provisions about foreign exchange instruments, and I'm not sure that it would be possible to draft a provision about foreign exchange instruments, taxation of foreign exchange instruments, in a way that was straightforward and comprehensible to everybody.